Thank you, Mr. Speaker. Contrary to what the previous speaker just said, I don't think this is a very complicated piece of legislation at all. I don't think changing a time frame in a piece of legislation is particularly complicated. Might be complicated for Mr. Heatley, but in fact it's quite a simple change in that regard. This bill does amend Section 107 of the Resource Management Act, and it aims to limit the period for which a consent can be issued in what are called exceptional circumstances to a 5-year maximum from the current maximum of 35 years in the RMA. And 35 years is simply the default position in the RMA. So if you don't define another time frame in the RMA, it's automatically 35 years. So 35 years wasn't chosen for any particular special reason. It's simply just the default provision of the RMA. And as Phil Heatley said in his speech, it has the way it's been applied, this particular Section 107 of the RMA, has been upheld by the Environment Court. I find it very interesting that Minister Heatley said we should therefore never ever pass legislation where a court has made a determination, because I sincerely hope, and my colleague Ruth Dyson would agree with me, that the government continues to uphold the Board of Inquiry decision on the Ruataniwha Dam, which would have turned the Tukituki River toxic. I sincerely hope that they're going to abide by Minister Heatley's comments the former Minister Heatley's comments that we should just stand by these decisions and not overturn them, and that we won't see any legislation in this House from the National Government overturning the Board of Inquiry decision into Ruataniwha, much in the way that they overturned the court decision on paid family caregivers. But consistency has never been one of Mr Heatley's strong points, so I'm prepared to let that slide. Mr Speaker, this bill came about, and I want to commend the member Catherine Delahunty, not just for the bill, but for the years and decades of work actually that she's put into the issue of the Tarawera River and the Eastern Bay of Plenty. Now, of course, this bill, if it passes, won't impact on the consent that the mill has been given on the Tarawera River. They've still got another 21 years to run of a 25-year consent. They applied for 35, they got 25. And that was 4 years ago, so there's still 21 years to run. So this won't impact on that consent, but it could potentially impact on future applications for consent. Now, and it should be acknowledged that the Tarawera River has gone basically to hell and back, really, in terms of what a river can cope with. And in 1954, there was an Act of Parliament that was written that actually had the explicit purpose of enabling the mill to discharge waste into the river. And it really is unthinkable that Parliament would pass that kind of legislation today, but it did in the 1950s. And before I came into Parliament, I was a team leader of a persistent organic pollutants laboratory, and we tested organochlorines, and we tested a lot of product from mills around the country to make sure that the kinds of chemicals that were being used in the past, which persist in the environment for a long time, which are very expensive to remediate, which are damaging to human health and to the health of other animals and to anyone who uses the river, to ensure that those chemicals are not being used again. So in 1954, that Act of Parliament was passed, and the river did basically, as it was called, become a black drain. Now, in 2004, the Bay of Plenty Regional Council actually came up with a catchment plan for the river because of the concerns, and it wasn't just the mill actually in this river. There was the Kawerau wastewater, which is all going into the Tarawera River at the time. There's geothermal on the river, as well as natural geothermal vents in the river, which do affect water quality. There were still broken pipes leaching into the river from the Edgecombe earthquake. There was runoff, obviously, nutrient runoff, and also forestry. So there was, but all these things were impacting on the health of this particular river. And in 2004, a catchment plan was developed, and the health of the Tarawera River is very different today to when it was considered a black drain. And even the Parliamentary Commissioner for the Environment said it's no longer really valid to call it the black drain anymore, because there has been significant improvement in the river, although, as with all these things, there's still a way to go. So in 2004, the catchment plan was put in place. In 2010, the mill applied for their consent under Section 107 of the Resource Management Act. Members have talked about, and I just want to put on the table that I was very sorry that I couldn't get to the submission hearings in Whakatane, as were members of the Labour Party. We weren't able to have any members there because that was, of course, the week of our colleague Parakura Horomea's tangi, so all of the Labour members were in Uawa, and that's actually very unfortunate because I would have I think we would have benefited enormously, and we acknowledge that we weren't able to be there to hear the submissions, and so that has made it more difficult for us to make a determination on the bill, or to hear all the points of view, particularly from those people who live around that particular river. I should have said at the outset we will be supporting this bill at second reading. I have tabled an SOP in my name for the committee stage around the time frame, and I'll come to that when I discuss the time frame a little bit further on. Because this bill isn't about whether or not there should be an emergency provision, an emergency discharge provision in the RMA, because this bill doesn't get rid of the emergency discharge provision. This bill is about the time frame, about the maximum allowable time frame for that provision to be accessed. And as we said before, it takes it from a maximum of 35 years down to 5 years. Now, I get, as environment spokesperson, I have to say I get a little bit nervous around a piece of legislation as important as the Resource Management Act, about making wholesale changes to it from opposition, particularly when we weren't able to hear submissions, because there may well be unintended consequences. And so we went to the member in charge of the bill, Catherine Delahunty, and said to her, look, 35 years to 5 years, we're a bit nervous that might be too strict, but we would be prepared to go to 15 years as a maximum right now, because that allays our concerns that there might be unintended consequences. It gives us that wiggle room when there is uncertainty. So the SOP in my name is to change the maximum time frame in the legislation from a maximum of 5 years to a maximum of 15 years. And we believe that going from a maximum of 35 years to 15 years actually is a significant improvement. Now, the member in charge of the bill doesn't agree, and that's absolutely her right. And I completely respect her decision, and I thank her for engaging with us and negotiating with us in really good faith. We weren't able to come to an agreement, but this is an issue. The health of our waterways is an issue, and so we didn't want to just vote against the bill because we didn't come to some agreement with the member in charge of the bill. We want to be able to support it at second reading and say, well, we'll test in committee stage, we'll test the House on my SOP, which extends that time frame out and allows more time for those resource consent conditions to be met. So And I also want to point out the Parliamentary Commission for the Environment, who supports this bill, she did make the point in her submission where she said, clearly there can be cases where it will take time and a great deal of expenditure to treat discharges to an acceptable level. But if it's not practical to meet a particular standard at the end of 5 years, there is nothing to prevent an application for a second consent. And that's absolutely correct. And that's really, I think, kind of the crux of where this bill is at, is it is likely, or it is possible that there will be times when a 5-year consent period is too strict. And sure, a company could come back and apply for another 5-year consent. Our concern with that is that it may actually be cheaper for them to up sticks and leave a polluted river for ratepayers and taxpayers to clean up, than to actually go through the process of trying to access potentially the capital that they need, often from overseas, to remedy the problem. So that was one of our concerns, that the 5-year time frame might actually result in us being left with rivers to clean up ourselves if it's easier and cheaper for a company to say, well, you know, we can go and invest this money in New Zealand on these environmental matters, and then within 5 years we may have to apply for another consent, which we may not get. Partway through, we may have spent money which ends up being stranded. So from our perspective, we thought if you went to 15 years, that's you don't have that issue as you do with a 5-year consent period. Excuse me. So and again, I'd just say we were also nervous about just plucking a time frame out of the year without being able to, from government, actually look at all the reasons why you might pick a certain time frame. So we've gone from 35 years to 5 years. I note that when the Green Party made their submission on the resource consent, they called for 10 years as a maximum consent for that particular consent. So I get a bit nervous about just plucking figures out of the year and saying this is the magic number, particularly when it comes to a piece of legislation as important as the RMA. But as I've said, I congratulate Catherine Delahunty for bringing this bill to the House and for her work on the Tarawera River. If this bill is to pass tonight at second reading, as I said, my SOP is on the table. It takes the maximum consent period from 35 years to 15 years, which I think is very reasonable. It allays a number of the concerns the National Party were outlaying, but it also would be far more certainty for the environment, and so I urge members to support that SOP.
Jackie Dean.
Thank you, Mr Speaker. I also